office of MPP Jagmeet Singh.
Is this Nader?
Sorry?
Is this Nader?
Hi, speaking.
Yeah, it's Robert Burgess calling. I just going over some of your emails. And the one you asked me what exactly my employer said that was a lie. The lie was the saying that I sexually harassed somebody.
Sorry?
The lie was saying to unemployment insurance that I sexually harassed somebody. That's the lie.
That you did what?
That I sexually harassed somebody.
The complaints were made, though, that you did.
Yeah, but it wasn't proven that I did.
Well,
she made complaints, yeah.
Their job is to report to Employment Canada that the complaints were made.
No. They said they investigated the complaints and determined that I was sexually harassing somebody.
Right, and they did.
Yeah, but their story isn't credible, though, that I was. They don't even give me the details in the unemployment insurance report. The details of the complaints aren't there. And there's no signed complaint from the girl.
But she does provide her testimony that she did make the complaint.
Not to unemployment insurance, no.
Well, she doesn't have to make the complaints to employment insurance. She has to make the complaints to her supervisor, to her boss. Why? Employment Canada wouldn't hunt down the... Why would Employment Canada go find her to make her give a report? That would be ridiculous.
No. The employer should have done that. The complaint, a sexual harassment complaint, if you go on to the Ontario Human Rights Commission website, it says the complaint has to be in writing.
For Employment Canada?
For them to determine that I was sexually harassing somebody, the complaint has to be in writing.
But she did
just like if you go to the police.
Right, she did make a written complaint to your boss.
Yeah. That was 7 years after the fact. That was February 7th, 2002. Which doesn't make sense. Like, why would she wait that long to sign the complaint? I don't know if that's her signature on that or not. And I can't get the police to investigate it, though. Because the trial, the
police aren't going to investigate whether the signature was fraud, like whether the signature was fake, like that. Why would the police have to do that? The police can't question the victim in that sense. The police don't do that.
No. If it's fake, she didn't write it. Somebody else did. So they can go there and look at other signatures.
The police have no reason to assume that it is.
Yeah, I say that I didn't sexually harass somebody. I say that she's lying about it. Because we were seeing each other at work, and she doesn't want her husband to find out about it. So she denies the whole relationship at the trial. But before that, there was nothing in writing. Did you look at the thing where I said the contradictions? Like, my boss says there was a complaint in December of '94. I had written questions and answers from Discovery, from the lawsuit. You know what Discovery is?
Is that during the trial?
Yeah, that's what you're like, a detective investigating a case before a trial. You question witnesses before the trial. I did it with written questions and answers to the employer. And in there, they say that she filed a third and final complaint, November the 23rd, 1994. But then my boss at the trial says there was a complaint in December, and then I have him read the question where it says a third and final complaint in November, and I impeach him. The judge even says you can't impeach him, but I did. So he's not credible what he's saying. Then
why did the judge say you can't?
I don't know. He said you can't impeach your own witness because it was my witness. But I had to call him myself, though, because if they had called her, I let the defendant call the witnesses. They would have called her first, and she would have said what she said, and he's sitting in the courtroom, my boss. So then he would have followed what she said, because until then they hadn't spoken to her about the complaints. That's why his story and her story don't match.
But it was also several years after the details of the case. Like, so even the judge mentions that, like, there's not an expectancy. Like, they don't expect them to remember exactly what happened word for word, date by date. That's just several years after the fact.
But why wouldn't they write it down if I really was sexually harassing her? Like a cop investigating on a threatening charge would write down what the threatening was, right? Of course
they did write down certain details in the complaint.
One of the complaints, which the girl said she couldn't remember happening at the trial.
Right, but that's because it was several years after the fact.
But she had just signed a written complaint a month before stating that I asked her on a date. That part she couldn't remember, so maybe it's not her signature on the written complaint. Maybe they faked it.
Right, but again, that's not something that, like, we can't.
No, I'm saying the police need to investigate that. But they didn't call me and say, "What's your side of the story? This is what your employer sent us." They just called me and said, "We're dropping the investigation." No discussion about it at all. And I'm like, the OIPRD don't know what the evidence is. They concluded the officer was right.
Right, but this all stems from what the employer said to Employment Canada.
Yes, that I was sexually harassing somebody.
And there was a report that they filed that included that. Was there not? Like, didn't they?
No.
Wasn't there a complaint made?
A sexual harassment complaint? I don't know. I know she filed one complaint, but my boss said to me, she says, "You're harassing her." I said to him, "I'm not harassing her. We're just seeing each other at work."
They still claim it, even though you don't claim it was, they claim it was. It's their responsibility.
Yeah, so somebody needs to investigate to see if what they're saying is legitimate.
Because they said that qualified privilege exists in this case, and that's why the employer has the responsibility to report to Employment Canada what the employee said, whether or not it's true. The employer.
Yeah, they have to tell the truth. That's what the malice is.
No, that's not what it says. It says even if the statements are untrue, they still have a responsibility to report them, because those complaints were made to him, to the employer. It's the employer's responsibility to report that to Employment Canada. Therefore, whether or not the statement is true or not doesn't even matter in this case, because it's qualified privilege. The employer had a responsibility to report that. That's what.
If that was reported, though, if she actually did say those things.
But she did.
No, but she didn't. I impeached her at the trial. She was.
No, or else that would have resolved the whole thing there. Clearly, it didn't resolve everything.
Oh no! I thought she was going to get up there and say I never sexually harassed her. And when she started throwing me under the bus, I realized I needed a lawyer, and I had no money, so I just gave up on the case. Figured I'd do it through the police. Like, nobody's investigated. Nobody checked any witnesses to see if me and her were in a relationship. Nobody asked any employees at work.
Because it's not, the police can't do that. The employer had the responsibility to do that. The employer did it. The employer provided the report. The employer provided the reports to Employment Canada, which is his responsibility to do so. You disagree with those reports, so you escalated it. But that's not the employer's problem. The employer had to do what they had to do. The police investigated to the point that they felt they needed to. You think they should have gone further, but there's a reason. You're not the police in this case, so there's nothing they can really do. Like, the OIPRD can't really rule against the police in this case.
Why can't they?
Because how are they? On what evidence do they have to inquire into this any further?
The evidence that I say it's not true. That's why.
But imagine if everybody who was accused of something demanded that police go further simply by saying, "I believe it's not true."
Yeah, but look at the contradictions.
The OIPRD would never be able to get anything accomplished, because every single time the person is just claiming, "Well, that's not how it happened."
No. It's not just my words, but look at the evidence, the contradictions, the stuff that doesn't make sense.
The contradictions are very minor discrepancies between what someone said in court versus what happened over almost a decade ago. It's made very clear throughout the trial that the details aren't expected to be exactly as they were when the initial incident happened. There's an understanding that when that much time passes, the recollection of what happened is going to start to dwindle a bit.
Yeah, that's why they should have written things down. But the woman signed a written complaint a month before the trial. At the trial, the lawyer, he says to her, wasn't there an incident on December the 12th where he asked you out on a date? She says, "I can't remember that right now." He could have then handed her written statement and said, "Read this into evidence," because it says it in there. But he didn't. Well, why would he not do that? Because it's not her written statement.
Again, that's your. Unfortunately, I'm not doubting your opinion, but that's at the end of the day, that's what you believe happened. But that's not.
No, I'm talking about the trial, though. That's what happens when the transcripts say.
Yeah, but that's not because it wasn't her signature. That
why else would he not hand it to her and have it read it into evidence?
Right, but you can't just because you claim that's what it is, that doesn't make it.
I'm not saying it makes it true, but it makes it, the police should investigate it.
Why would the police can't just investigate that? She said that she doesn't remember. That she's allowed.
No. The police need to investigate as to whether that really is her written statement or not.
Well, why would they assume it's not? What evidence do they
because
have?
I just told you the lawyer could have handed it to her at trial and had her read it into evidence.
He didn't have to do that, and he chose not to.
Yeah, but why would he not, though? If it was really her statement, he could have gotten it in there and said, look, he did ask you, I want to date, and you said no, and then he said, that doesn't matter because you're married.
Right, and that could possibly be true, but that's not under, there's no reason for the police to have to do that, to investigate that. The lawyer didn't have to do that. The lawyer chose not to. Now, you can inject and say, well, he should have, but it doesn't matter. He didn't have to, and he didn't.
I'm not saying he has to, but if he didn't, if it really is her written statement, what reason would he have for not entering it into evidence?
He just chose not to. That's the right.
No, but he's a lawyer, though.
Attorney.
No, there's no reason not to, though.
It doesn't matter, though. Whether there was a reason or not, there wasn't a reason. He chose not to. If he was well within his right to do that, that's it. You can't just investigate things because you think there was something more to it.
Because it doesn't make sense. That's why.
Well, it doesn't make sense to you, but in this case, it's difficult for. I'm just trying to understand what reason there is to go any further than what's in the action that was already taken. And I can't personally see any reason for, based on what I've seen, that anything else needed to be escalated.
Well, what they did at trial didn't make sense. I mean, the cops use common sense a lot. You know, a guy has an alibi, and you say, well, the alibi doesn't make sense because we got a video of you driving by the place at such a time. Let's say your alibi is contradictory.
That's clear evidence that example was a very good example of evidence. What you're saying is your opinion of what. I'm
saying there's enough there for the police to investigate to see if that really is her written statement or not, because that matters if it is or isn't.
But there's no reason for them to consider it not her written statement. She signed it. She has made no claim that it wasn't her signature.
And no one asked her if it was her signature.
But nobody had to ask her that.
Why did nobody have to ask her that?
Because no one was forced to. No one's forced to ask her.
Yeah,
there was no reason for anyone. No one had to do that, and no one chose. Nobody did. There's nothing more to that.
Why would the lawyer not have enter that into evidence at the trial? It makes no sense that he wouldn't. It's a strong piece of evidence.
Right, but he chose not to for whatever reason, and there's nothing.
Yeah, but give me a logical reason why he wouldn't, though. If you don't have a logical reason, then something needs to be investigated.
No, that's not how police investigations work. Just because to that lawyer it made sense not to do it, to everyone else in the courtroom it made sense not to do it. You think?
No, but you don't know if it made sense not to do it, although you haven't talked to the lawyer.
But neither have you.
That's what I'm saying. That's why I want the police to talk to him.
But you can't do. Imagine if that's how all police investigations worked. If the suspect in the case, or the person being accused of something, simply said, I think someone should do this, I think police should investigate.
I'm not just saying I think it, I'm saying I have a logical reason why it is, too.
Your logical reason is that you think something isn't making sense.
Yeah, it doesn't.
Imagine if every suspect based their desire for an investigation on what they think happened, and the police had to investigate what every suspect thinks.
Everything that makes sense they have to investigate.
But that makes sense. That makes sense to you.
It doesn't make sense to you. That they wouldn't. There must have been a good reason why they wouldn't have entered that into evidence.
No, because she said she doesn't remember. He chose not to show her the
complaint. So why would he not do that? Well, give me the reason.
But that's the problem. He doesn't have to provide a reason.
I'm not saying. Yeah, I'm saying it makes it look suspect, though. The written complaint makes it look suspicious, because he would have entered it into evidence. So there's enough there for the police to say, this written complaint doesn't seem credible, because he would have entered it into evidence at the trial, but he didn't. Let's investigate that.
But that's your opinion on what doesn't make sense. So police.
That's everybody's opinion that doesn't make sense.
No, it makes normal sense to me. The person chose not to do it. They're well. As long as someone's well within their rights.
I'm not saying he wasn't within his right to do it. I'm saying it doesn't make sense that he wouldn't have entered into evidence.
Right, but again, the police can't simply investigate something based off of something like that. Like, that's just not. That there's no reason.
What do you mean the police can't? Police investigate he said, she said case all the time.
And do you know for a fact that the police didn't investigate that at all?
No, I don't know. The police didn't tell me the evidence. They just called me and
said. Why would the police have to tell you as evidence? So now we're not even sure if the police did or not.
Because I'm the victim, that's why.
We know the police could have investigated it.
Then they can then tell me that.
But
they can tell me that. Like
that there wasn't enough evidence to continue with the investigation.
Based on what?
You're basing this whole case on the fact that that person that they chose not to investigate a signed report by the individual that when there's no evidence showing that, assuming that she didn't actually sign it. Like at a certain point, that's what your whole case is hinging on.
No, it's not that. It's they didn't write things down. The day of the complaint, they didn't write down the details of the complaint. They didn't.
Again, those are very minor, little.
It's not minor that they didn't write things down. In any kind of an investigation, you write down what's said. The Ontario Human Rights Commission says that complaint has to be in writing.
Right, and they do have it in writing, though.
7 years later, not the off.
But they also have the initial complaint from the time that I saw that you sent over.
Yeah.
So those are initial complaints when at the time of it happening.
Yeah, but there's no detail there, though. So maybe they don't know what.
It does mention. It doesn't mention maybe as much detail as you would like them to, but there is detail in it.
No, they don't say what I said to her. They just say you're sexually harassing, you're annoying her.
Right, and she explains how some of it was. She goes into some detail about how you annoyed her at work.
Yeah, that's the first time it comes up at the trial, 7 years later. Why wasn't it mentioned before? Why didn't my boss testify to that? If he didn't write it down, he would have remembered.
I do recall looking through pieces of documentation where they talk about the complaints from the time, at the time when it happened.
Yeah, the one where I supposedly asked her out on a date.
Right, so there is written down documentation at the time of it happening of you harassing.
But she couldn't remember that happening, though, and she just signed a written complaint a month later.
Several years afterwards.
No, a month before she signed a written complaint stating that I asked her out on a date. Yet at the trial she doesn't remember that? That makes no sense. How is she not remembering it? And she says how traumatizing it was for her, all the sexual harassment, yet she doesn't remember the details?
Because again, it was quite a long time afterwards. The court acknowledges that because of the time in between the time that the incidents occurred and the questions taking place in court, the memory is not going to be spot on. That's common sense.
But she's got a written statement, though. She can look at that and get her memory straight. To refresh her memory, she can look at her written statement.
But again, she wasn't asked to look at the written statement.
Yeah, but why would he not ask her, though?
But
think about it. You're being sued.
Look at the written statement. She would have. What are you assuming would have happened if she was forced to look at the written statement? That she would have said.
She might have said that's not my statement.
Well, based on why would that have happened? Why would she not have made aware of that report?
Because they were trying to get rid of me. Well, when the first complaint, I was brought into the office. My boss says, Wanda says you're harassing her. I said, it's not harassment. We're seeing each other at work. And we had a bit of a fight. And he said, I will speak to Wanda. That's the last I heard of that complaint. Right?
But those complaints were filed. Those complaints were made. And
yeah, but is it actually a sexual harassment? Is there enough evidence that I sexually harassed her, though, in the complaint?
From her perspective, there isn't. But from her perspective, there was. And from the employer's perspective, there was.
No, not from the employer's perspective, because he doesn't tell me the details of the complaint. Right? The second complaint, they just call me in the office and say she's filed a second complaint. You're suspended with your gives a written warning and 1 day suspension. They didn't tell me anything. Like I never said anything to her. They didn't get my side of the story or anything. Why would they not do that?
Several years ago now. There's no point in even debating that.
What do you mean there's no point in even debating it? It says that they're not credible. Because if they
not credible? How is it not credible?
Because if you investigate a crime of some kind, you talk to the suspect and get their side of the story. That's why. And they didn't do that.
Right. Well, I mean that's how is anyone supposed to verify that they didn't necessarily talk to you besides you saying they didn't talk to you?
They didn't say. They would have said he said this, he denied that. He said, and there was a witness to this, because she says I was hanging around, following her all over the plant. Where's the witnesses to this? And at the trial was the first I'd heard of that.
In the written complaints, that was mentioned.
No. I don't think it was.
The complaints are written. Like I'm still having a hard time understanding the stuff that you forwarded over from the time that it happened. There were reports made that indicate the harassment that she's referring to.
No, in the report that was sent to unemployment insurance, which is the first time I've seen the details of it. It says I was annoying her. It says this behavior must stop, or you will be in serious trouble. The third complaint, they say you asked her out on a date. She said no because she's married, and I said that doesn't matter, which never happened.
Right. Again, that's impossible for anybody to verify. The fact of the matter is the complaint was made, and it was written down. That's what he sent, and then that led to him having to send that to Employment Canada, which he had to do.
Not if it's not true. He doesn't have to send it to him.
No, it doesn't matter if it's not true or not. That's the definition that's what qualified privilege is. That's why it's so important to understand that.
No, it says nothing. I sent you.
Qualified privilege exists whether or not the statement is true or false, as long as it's not made with malice. Malice does not mean true or false. The fact of the matter, it explicitly says that the statement could even be false, and the person still has the responsibility to report it. That's qualified privilege.
Yeah, but if they're the ones who investigated it, though, they're lying. Like a secretary dictated a letter. That's qualified privilege. They can't lie to unemployment insurance. Come on, anybody tell it.
What if they didn't? He didn't. Doesn't matter if it's true or untrue. If he was given that, if someone complained against you for sexual harassment, he has an obligation to report that to Employment Canada that you were fired due to that.
Yeah, he has an obligation to investigate it first and determine whether...
The initial complaint.
Huh?
He did. He had 3 complaints made against you. By the 3rd complaint, he had to act. That's what he's justified.
The third complaint happened while I was suspended. I was permanently suspended. They called me into work over the weekend. They said, come in Monday and we'll have a meeting. And that's when they gave me my termination letter. They said, she's filed a 3rd complaint against you now, so you're fired. How could I have sexually harassed her? I wasn't even at work.
It describes whatever the timeline is in as the reports were indicated. That's what went on paper. Like that's how the reports were made. Like what? Why wasn't this hashed out in court? Like what? I did
testify at court, but I can't get the transcripts.
As clear as you say they are.
I can't.
Court would surely have resolved them.
No, I needed a lawyer. It's too complicated to do it yourself. I have no money, and there's no legal aid. If I'd had a lawyer, I would have gotten a lot more money. I would have won. But it's too complicated for me to do by myself.
But all your arguments are based on sort of what your understanding of this and your perspective and what you think this was, and these little minor details like this person didn't remember something several years after the fact. These aren't grounds for police investigations.
It's suspicious activity.
It's not suspicious activity. You had complaints against you when you were working that led to you being fired. That led to your employer having to report it to Employment Canada. That's it. Like, it's escalated now to this point. However, it's very commonplace that when people just get fired for complaints against them, that they have that reported to Employment Canada. It's the responsibility of the employer to do that.
it defines the malice as doing it without any regard to the concept of it having it affect the person.
No, that's not what qualified privilege is. Qualified privilege is...
I'm talking about malice, not qualified privilege.
The employer had every responsibility to do what he did. He had to report it. Now, you say that the reports weren't true, but they were made by the employer, by the employee. The complaints were made, they were written down, and when you got fired, they were reported to Employment Canada. That's it.
Yeah. Hang on, I'm just going to open up my thing here for malice. Says if the plaintiff can prove that the defendant was not acting honestly when he published the comment. That's the pocket law book that I have.
Right, and then also the Supreme Court makes it very clear in their ruling of qualified privilege that the defendant is free to publish with impunity remarks which may be defamatory and untrue about the plaintiff.
Yeah, as long as there's no malice. But I'm looking at the definition of malice.
The responsibility isn't on the employer to determine that the employer has already determined that the complaint made by your coworker was legitimate.
How did you know that?
Whether or not you agree with that complaint or not, whether you believe that complaint is true or false, the employer.
Well, I know it's not true because I never sexually harassed her.
Right, that's your opinion though. That's
not my opinion. That's what happened at work. I was there.
Unfortunately, no one can verify that because somebody else has already. Because that's how your perspective of what happened. But again, imagine if everyone who was accused of something simply said, "Well, that's just not true because I don't believe it happened." That's just not how it works. Those aren't grounds for police investigation.
No, not just that itself. You would ask them, "Why do you believe it's not true?" And then they would say, "Well, look at this witness said this," and then 2 minutes later they said this. That doesn't.
But think about how little you would have in response to that question. If someone said, "Well, why do you think it's not true?" Most of it would be based on your own testimony of what happened.
Yeah, and the contradictions, and how his story was different than hers.
Several years after the fact.
No, he could have looked. His lawyer could have had him look at the written statements and said, "Here, refresh your memory with that."
Everybody's memory during that. I read the whole court proceedings. Everyone's memory was hazy. Everyone was responding with answers that made reference to the fact that they don't necessarily remember the details. And that's very common with cases that happened several years after the fact.
So all the more reason they should have written things down. On the third complaint, I'm telling you, it didn't happen. I was suspended. I wasn't even at work. Their own evidence says that there was a complaint, a third and final complaint, November the 23rd. Then they go on to say there was a complaint on December the 12th. Their own evidence, their own discovery evidence says that's not true. I impeached my witness. I can have him charged with perjury.
No, because you can't impeach your own witness.
No, the judge is just talking like metaphorically. He's not saying it's not going to help your case if you impeach your own witness. He's not saying you're not allowed to. You can impeach your own witness if you want to. I simply did it in the O.J. Simpson trial. But
honestly, at this point, again, I still don't see, and this is after several dozen emails of trying to understand the case, and it's clearly not. It doesn't make sense to me. It's not as straightforward to me as it is to you, and because of that, it's outside the purview of our office at this point. We're not a legal office. I can't hash out all the facts from fiction in the case. Our office, as previously recommended, is recommending that you seek legal counsel. And I understand that that financially you say you might not be able to pursue that. We provided you with some resources as to the legal clinics, lawyer referral service, inquiring into potential pro bono work, but otherwise our office is not going to be able to do much more than what we've been able to do. because I don't want to waste your time anymore, right? So it's in your best interest to pursue this matter in the legal realm if you want to pursue it any further.
Well, I can't though. Like, I can't sue them again.
And the police aren't going to investigate this. There's no, from my perspective at least, I would suggest that you don't pursue that any longer unless you have some new evidence or you do get some sort of new legal defense that could make a case. Because if I can't hash out I can't even make sense of it, to be honest. And it might be in your best interest just to leave it alone and, I mean, it's just move on at this point, or possibly find someone who would take on the case legally, but that's going to be a very difficult thing for you to do.
So what about the email I sent you on the 9th of January about the OCPC not investigating my complaint against the Toronto Police?
Right, they said they can't investigate a case against the police not investigating them.
Wait, where does it say that?
That's what you told me.
No, that's what they're saying. I'm saying, where does it say that? Because there's nothing in the Police Services Act that says that.
How are they supposed to investigate the police, not investigate themselves?
The police investigate police all the time. That's how the OIPID works. They sent the complaint to the police that's involved in the case, and the professional standards branch of that police department investigates your complaint. And then if you disagree with the decision, you appeal to the OIPID.
And is this all related to the same case?
No. Talking about complaints against police being covered up.
So these complaints are about the other complaints being covered up.
No, there was a complaint in '99 that I filed.
Another complaint
against this has been going on for 20 years. Police been covering up crimes.
What's the end goal? Like
I want the corruption stopped. That's what I want. I got my lawyers screwed me over and stuff. I want to put them in jail.
You want to put them in jail?
My lawyer sent a complaint to the employer saying we want a copy of any written complaint because she says the complaint has to be in writing. We want transcripts for any investigation. All they sent back was a letter saying if this goes to court, it will be fought vigorously. My lawyer says to me in a letter, they clearly state in this letter they had cause to fire you, and she quit, which she's not allowed to do.
The lawyer's allowed to quit?
No, I got the rules from the Law Society of Upper Canada. The lawyer cannot just quit like that. If you're asking her to do something immoral, an area of law she doesn't practice in, sure, but she can't just say I'm quitting.
Or if it's an area of, there must be something in regards to if they don't believe there's a case to be made.
She says that they clearly state in that letter that they have cause to fire you. All they said in the letter was if this goes to court, it will be fought vigorously.
There was more. I'm sure there was more in that letter than just that.
No, they just.
They clearly had stated they had cause to fire you. Is this the same case of you being fired for the sexual harassment complaint?
Yeah.
So again, someone else is already another.
No, lawyers lie to their clients. My fourth lawyer took the case on a percentage.
So what incentive? Why would this lawyer not want to?
Because she's scared of hard work. Lots of lawyers lie to their clients. She's scared of hard work. She's scared of doing a trial.
A lawyer is scared of hard work. That's why she dropped your case.
Yes. I talked to at least 10 lawyers. One lawyer said, what do you want me to do? I said, they'll get me my job back. He says, was it a union shop? I said, no. He says, I can't get you your job back if it's a union shop.
How many lawyers have you spoken to about the case?
Oh, at least 10. But I had...
How many of them have taken on the case?
I have one lawyer that wanted a percentage. He took on the case.
One lawyer out of 10.
Yeah, but you got to look at the evidence and what they're saying, and then ask, is it making sense?
But they did. At the very least, they looked at the basics of the case, like what I've looked at.
But they give me different answers, though.
So lawyers who have looked at more than what I've looked at, trained lawyers who've looked at more documentation than what I've looked at, have determined that there is clear cause to fire you.
The one lawyer said that. The other one said I didn't have a case.
She dropped the case because she's afraid of work.
Yeah, lots of lawyers do that. Lots of lawyers lie to their clients because she'd rather be doing a will than doing a trial. She'd rather do research for other lawyers than doing a trial.
You don't think that you think it's just a coincidence? that a lawyer, a trained lawyer, would say that no, there's no case here, and I need to move on.
What do you mean a coincidence? She's lying.
Why? Like, you haven't gone anywhere with the case in that amount of time.
Look, if there was qualified privilege at the trial, why didn't they raise that defense at the trial? They never brought it up.
Well, they clearly didn't even need to bring up that.
They could have had the case thrown out before he even got the trial, if it was qualified privilege. They could have filed a motion and had it thrown out the day after I filed it.
No, because the police investigate. The police.
No, I'm talking about
no, because you're mixing two things. You're saying you accuse them of defamation. The police claimed qualified privilege, not the
yes, and that would have been a defense at the trial too, at the civil trial. But they never used that defense. Yes, why would it not necessarily be?
No, because it's two separate people that made that. The employer never made the argument of qualified privilege.
But they would have. You're saying there is legitimate qualified privilege. So they could have used that as a defense, but they didn't.
No, because the police, the accused had to prove that it wasn't made out of malice.
The defendant doesn't have to prove anything. I have to prove the case.
Right, and exactly. If anything, that's exactly it. Why they don't have to provide the defense, because you have to prove.
But they could have filed a motion saying the lawsuit is baseless, so there's no point in going to trial.
Again, that's not an argument. They chose not to. They didn't have to.
Now you're just screwing me around, man.
No, I'm trying to understand.
Yeah, you were. Why are you saying it's just I think that? I don't just think that. It's the facts of the case.
It's not, sir. I completely. I just think that you shouldn't. I want to make sure that you don't waste any more time speaking, because to me, it's not the facts of the case. Because it's not. It's what you believe is a fact. So that doesn't make it a fact. Like, there's two sides to this.
So what I did at work is not a fact.
Make it a fact.
What I did at work is not a fact. I was there. I know whether I said these things to her or not.
Is incapable of determining between that, right? We're not a legal office.
It's just common sense.
Well, the police, it wasn't, right?
The police are doing it because the courts are swamped and they're under pressure not to add to that, so they don't arrest people. A cop told me they do that. A cop in Hamilton told me they do that.
Well, no one can do anything with that. That argument is. It might very well be true, but we can't do anything with that argument.
What do you mean you can't? You can complain to the Attorney General about the YPRD not investigating those things.
Based on what? Based on a police officer that told you that it's because the courts are swamped.
No. You're saying there's nothing we can do about it. But I filed complaints against cops for doing that.
There's nothing we can do about it by way of verifying whether or not it's true. How are we supposed to? We can't just assume that. No,
I'm saying there's other complaints where it's obvious the cop was lying about his reason for not filing charges.
I'm completely with you on that. I'm not saying that the OIPD is perfect or that the complaints process is perfect. I've dealt with several cases involving the OIPRD, and it's not a perfect system, and it's a very flawed system. I completely agree. But in terms of the specifics of your case, there's very little that our office can do in terms of vetting the facts beyond which the court has already done. So again, our office is suggesting that if you want to pursue it any further, that you try to find as many legal avenues as you possibly can. There's always, if you can contact media or try to get your story picked up somewhere.
The media won't go up against the police on that. I've given them clear stories of police corruption, and they won't do anything about it. They won't do it.
The media covers the police corruption all the time.
Oh, no, not a big story like this. If they did a story on all of the complaints that I've filed, there would be police going to jail. The media is not going to be responsible for that.
About somebody getting a wrongful dismissal case?
No, not about the cops lying. The cops not arresting people because they're under pressure because the courts are swamped.
The police have covered the media have been covering major stories about the police.
Yeah, and there's stories where the police have done that.
Well, huge stories. Why? What incentive?
Because it would lead to the police being arrested. That's why. The Hamilton Spectator told me, we're not going to do a story on this, but if you get it in court, give us a call.
Right, because the court is the ultimate arbiter of whether something is credible or not. And
the news media has done stories on police before it goes to court.
Why? Because how is the media? Because the media is in a similar position. How are they supposed to verify or vet?
It's in the stuff. The complaints are in writing.
Right. Now we're just backtracking to what we already. It's a circular argument now. We've already confirmed that there were complaints made, that the discrepancy...
No. I'm talking about that. I'm talking about the cops not arresting people because they're under pressure because the courts are swamped. I've got complaints. I was assaulted at the club I went to, and I went before a justice of the peace and told her what happened, and she said, what he did is not assault. And the guy punched me on top of the head while I was bent over putting stuff in my gym bag. I wasn't attacking him or anything. He just walked up and punched... Huh? Yeah, this is a different case. And the justice of the peace said, not enough evidence. He said to me, if you go around telling people I'm a liar, I'm going to beat the shit out of you. I asked justice of the peace, is that threatening? She says, I can't say. Well, wait a minute, go look it up. And I looked it up myself, and it clearly is.
Verify that person said something like that.
She's not determining whether it's true or not. She's just listening to my evidence. She's making her decision.
And she did listen to your evidence.
And she said that whether that's assault or not, she can't say. Whether that's threatening, she can't say. Well, she can go look it up. She's got a law book there. She's got the criminal code, a copy of the criminal code.
Okay, but even if that was threatening, what's her? She listened to your evidence, and what was the result? What was the end result?
Well, she said what he did to me is not assault. Clearly it is. Hitting somebody on top of the head when they're not attacking you is assault.
What was the other claim? What was the
threatening?
The other person.
She says, I said, is that threatening what he said to me? She says, I can't say. Well, go look it up then. She didn't even go look it up. She just said, I can't say.
Right, and then she ultimately, after listening to your evidence, decided that it wasn't assault.
Yeah, which clearly is assault. And you look up the definition of assault in the criminal code, it's assault. You're using force against somebody.
I'd be surprised if she was debating whether or not the person... She's probably debating whether or not she can verify that what actually happened. Was there footage of it?
No. See, you're looking for ways out of this.
But so how is she supposed to verify that it happened?
She's not listening to both sides. She's just taking my evidence and determining whether there's enough evidence to file charges. I don't know if she's going to call him or not. I gave her his address and stuff, I don't know if she called him or not.
You don't even know if she did or not, but you're...
No. At that day, the day of I talked to the justice of the peace. She says She said I can't put this before the court because what he did is not assault.
And why did you go to the police for it?
Yes, I went to the police and see about having her charged with obstruction of justice. And the cops said the justice of the peace is right because the assault charge would be hard to prove. But the criminal code says anyone who willfully attempts to obstruct justice. So what she did is an attempt at obstruction of justice.
No, but how do you know? But what was the initial investigation into the assault that you brought to the police?
I went to the police. They took my report. They gave me the number for the JP. They didn't investigate. That's what I'm saying. They don't investigate stuff like that. Police won't arrest people. I had my stuff. My landlord stole some of my stuff out of my room. I complained to the Hamilton police.
How do you know the police didn't go and talk to the person that you accused?
They didn't. I didn't have a police report with me. All the justice of the peace had with them in front of her was me.
But why didn't you? How do you know the police didn't go to the investigation?
I don't know if they did or didn't.
So how are you making this claim then?
Guy, there's all kinds of cases where it's he said, she said, and there's convictions. One person says one thing, and another one says, no, that's not what happened. This is what happened, and the jury believes the victim and convicts the guy.
No, very rarely do those court cases ever.
They just had drug dealers testifying against Toronto cops in Toronto, and they got convictions.
Right, but that testimony is usually part of a bigger trial. Never a case is never just based.
Sure, it is. The rape cases. Yeah, she consented to it.
You're talking about someone hitting you on the head.
Saying you're saying this is not just he said, she said. Cases never happen like that. Rape cases are like that. He says she gave me her consent. She says she didn't. That's a rape case. That's a he says, she said.
Right, and then in that case, well, the charge of rape is very different than
no, I'm not saying it's not different. You're saying there's no case where it's just he said, she said.
No, cases of that scale, of like a simple. Imagine if you just imagine if anybody could just go to the police and say this person hit me, and then boom, we got to go to a court. The courts don't do that. They vet cases before they go to court.
But the justice of the peace didn't do that though.
How do you know that the police didn't talk to the other person?
But the justice of the peace didn't have a police report in front of her. I had the meeting with the justice of the peace. It took about a half hour, and at the end of it, she said what he did is not assault. So she's saying, even if you're telling me the truth, what he did is.
How do you know all the information she had?
Because she decided that she just met me and just heard about the case when I showed up at the justice of the peace hearing.
Right, but how do you know what information she had in front of her?
No. I called them and said I needed a hearing with the justice. They didn't ask me for a file number or anything like that. I showed up. She said, "What's your name? What's the charge you want to lay?" And I told her assault. And she took the information from there. And at the end of the hearing, she said, "Not enough evidence. It's not assault."
Well, because there's not enough evidence besides the testimony that someone hit you on the head. Now she's going to charge someone.
She didn't. No. I misspoke when she said not enough evidence. She says it's not assault what he did. She was believing what I was saying, but she says what he did. What you're saying he did.
I'm not sure then, because I can't now I'm just hearing your side of it. Like, what am I supposed to do with that?
I have the transcripts with the justice of the peace, and I went to the police, and the police screwed me over. The police refused to investigate the JP.
But what? You don't even know if the police investigated the initial person.
What's that got to do with anything? The police didn't say they did. I got a written letter from the professional standards branch.
You know for a fact you know for 100% fact that the judge didn't have any.
The JP.
Any documentation in front of her besides what you were saying to her at that point.
Well, she couldn't have. When I called, she didn't know what I was calling about. She just gave me an appointment. I showed up.
But they also get documentation based on your name, based on whatever they have in the system.
How do you know that?
How do you know? So that's my point, though. How do you know that?
Because the JP said that what he did, what you're saying that he did, is not assault. She didn't say, "I don't believe you." She didn't say, "I have other evidence to contradict your evidence." She said, what you're saying he did is not assault.
Why would she not want that?
Because of the same reason the police won't investigate people. The same reason, because the courts are swamped and police are under pressure not to act that. And JPs are under the same pressure.
But again, this is you assuming that the judge didn't have any other...
JP, not the judge.
On that.
Just justice of the peace, not a judge.
So you know again, I'm asking, so you know for a fact she didn't have any other case? You know for a fact that the police didn't investigate your case at all?
I went to the police and asked them to investigate justice of the peace.
Before that, how do you know the police didn't investigate your assault case?
I don't know, but she didn't have a report in front of her.
You know what she had in front of her. You know what she was briefed on.
Yeah, she had nothing. She had a tape recorder in front of her. That's all she has. She was tape recording the hearing.
Right, and what did she say about the hearing?
She says what you're saying he did is not assault.
And how do you know she didn't have prior documentation from what maybe would have...
No. She's not saying I don't believe you. She's saying what you're saying he did is not assault. She says some guy walking up to you, punching you on top of the head while you're bent over putting stuff in your gym bag is not assault.
I'm not sure. I'm just literally I'm taking your word on everything you're telling me right now.
I have it. I sent you the thing with the complaint in it on January the 9th. Got the attachments with the complaint in it. Now I complained to the Toronto police about the OCOPs not covering up my appeal.
There's a lot of people conspiring against you.
Yeah, there is. I'm not delusional. I have mental illness.
Why would all this happen, though? Why would people go to this far of extent just to persecute you?
Not just me. They're doing it to lots of people. Go on the internet and look at There's lots of people complaining about the OIPRD.
No, again, I'm with you on the OIPRD not being a perfect organization, a perfect body. There's I'm not doubting that, but okay. Let me see. So you say right there, you don't have a police report there? She says, I do.
I don't remember her saying that.
It's right here in front of me. She says, you will have to confirm that day for me. Okay, you now... And you ask, you don't have a police report there? She says, I do, but I can take it from...
Yeah, but she still didn't say, I don't believe you. She says, what you're saying he did is not assault.
But that's because she has more documentation from the police report. So she has a police report.
But clearly that is assault. When someone just walks up to you...
Not to her. She investigated, the police investigated. They have a police report now.
No. Look up the criminal code for assault. It says using force against somebody.
I understand that by definition if someone hits you by an assault, but that's your claim that happened. So now people have to investigate the claim and see whether there's credibility to it. They investigated it. They determined that there was no credibility to the claim.
She didn't say it wasn't credible. She said it's not assault. She said what you're saying he did is not assault. Look at the threatening charge. She says I can't say.
Oh, hold on. Because there's a ton of information that you haven't even told me that I'm looking at right now.
Yeah.
She says, that you made the first physical... She even says you made the first physical contact. And
yes, but under the circumstances, pushing him away.
And then, hold on.
Yeah.
Yes, but it's pushing him assault. She says, yes, it is. So you pushed the guy, and then he did that.
Yeah, read on until you get to the Toronto Police. I'll tell you what, look at Section 34 of the Criminal Code. It defines...
No, sir, hold on.
No, it defines defensive person.
No, because this is one of the problems I've had with the case so far, is that every single time I look into it, there's more information that wasn't disclosed to me initially. So even right here, you pushed him first, and then he assaulted you. So you made...
No. You have to look at Section 34 of the Criminal Code. It defines defensive person. It says you have to be getting assaulted. You have to be facing immediate force in order to use physical force to defend yourself. When he hit me, I was bent over putting the stuff in my gym bag. I wasn't attacking him at any time. But you can't push. Someone pushes you, and then 2 minutes later you jump on them and beat the hell out of them. That's assault. You have to be getting attacked in order to claim self-defense.
You made the first contact.
Yes.
The judge makes it very clear.
It's not a judge. It's the justice of the peace.
Technically, I mean, if I brush up against you,
right. But that's got nothing to do with it, though.
That's different. That's unintentional contact. But if in a dispute or in anger we make contact with someone, even if we raise our hand and don't actually make contact, if we raise our hand as if we're going to, it's insult.
Right. So let's assume I did assault him first.
You clearly
right.
initiated the
contact. So he can hit me 2 minutes later. Is that what you're saying?
No, but the judge makes it very clear. You've made an assault.
What's that got to do with anything? That doesn't give him the right to hit me a minute later.
No, then she has to decide whether or not, based off of what you told me, based off of what was in the report, whether or not there's grounds for an assault, and clearly not. There was an altercation that occurred that you started.
But that doesn't give him the right to hit me a minute later. Come on, use your brain, man.
How it works? No, if you start a fight and you get hit, you can't then claim assault.
Yes, you can if when the guy throws the punches back. Right? If I hit him...
That's not how... You can't do that.
Look at Section 34 of the Criminal Code. It defines defensive person. It says you have to be getting attacked at the time you use force.
No, sir.
Yeah. Don't say no. It's the criminal code.
The judge makes it very clear. Yes, and the judge interpreted the criminal code as she saw fit. You can't start a fight with somebody and then when you get hit by that person, want to press assault charges.
Yes, you can, because he can't hit you after the fight stops. So we walk away from each other, and then he hits me. That's the
assault. That was in the police report. The police report doesn't say that that's how it happened.
That's not it is no police report. She doesn't cite the police report.
She clearly says she has a police report in front of her.
No, she's talking about my evidence that I gave her in the transcript.
No, she has a police report.
No, she didn't say she was citing the police report.
No, she has a police report in front of her. She says that.
Yeah, but she didn't say I'm citing the police report. She's saying, what difference does it make whether she's going after a police report? You can't, if someone hits you, and then you walk away from each other, you can't then go over to them and hit them. That's assault. You have to be getting a
police report says that's not what the investigation determined. The investigation
determined. And the investigation was covered up. Look at Section 34 of the criminal code.
Sir.
You are so screwing me around, man. You are looking for ways to not do this.
No,
look at Section 34 of the criminal code.
To be clear, you can't push somebody and then press assault charges.
So wait a minute. I push him. An hour later, we see each other on the street. He can now hit me.
That's not what happened.
I was not asking you that. I'm asking you, can he do that?
And an hour later, can someone come up and hit you? An hour later after, no.
No. Okay, let's say 2 minutes later.
I'm not sure where the timeline would go. I'm not sure where I would draw the line.
That's why I'm saying you have to look at Section 34 of the criminal code. It defines...
The judge interpreted the criminal code in this case.
You have to see how it's written to see if the way she interpreted it was reasonable or not.
Because it's not about whether she interprets; it's how she interpreted what happened between you and him. She's not saying that 2 minutes after he hit you.
No, she's saying after we walked away from each other, he hit me.
You were both trying to at the same time. That's different. That's unintentional. But someone just an ankle. But in the end, it clearly was what you would call not common sense. Yeah, it's very clear.
No, read the whole thing.
In the end, it clearly was what we would call, in our common sense, call a fight.
You have to look at Section 34 of the criminal code. Why will you not do that? You have to read that to see if the justice of the peace is reasonable in her interpretation of the criminal code.
What does it say about the criminal code?
It's long. It's about 2 paragraphs long. Just you get the internet. Go to the one where it says Toronto Police.
No.
The attachment.
No, because we're gonna hammer out this point here because this is.
Yeah, but you have to look at Section 34 of the criminal code.
Very cut and dry, in my opinion. Because I feel like you should kind of see it for what it is. As a judge, you got into a fight with somebody and then you press.
So isn't what he said to me threatening?
Sorry?
Isn't what he said to me threatening?
Which case is it?
Before he's getting into a fight, he says to me, "If you go around telling people I'm lying, I'm going to beat the shit out of you."
That's what we're saying. I don't know if he's pushing him.
It's towards the beginning of the transcripts.
Yeah, she says, I can't say. So when you ask her, so when he says to me, you go around telling people I'm a liar and I'm going to beat the shit out of you, is that threatening?
Right. So why doesn't she just go look it up in the criminal code book?
I can't tell you that.
Why doesn't she go look it up?
What I have in front of me, and that's that. This, unfortunately, can't go anywhere.
Well, why doesn't she go look it up in the criminal code?
Because that's not her job to look up.
What do you mean it's not her job to look it up? You're ridiculous, man. It's not her job to know the law, to go look it up?
No.
You're telling me a police officer can't go look up the criminal code? If he doesn't understand something, he can't look it up in the criminal code?
The judge can only operate with what she has in front of her.
Yeah, okay, sure.
Does that not make sense?
Yeah.
So you claiming that she was involved in the
That's
cover-up.
the evidence that's in front of her, not the criminal code. Come on, man. You got common sense. You're telling me if she doesn't understand the law, she can't go look it up.
No.
Is that what you're trying to tell me?
No, sir. You're misunderstanding how it works. The judge, when making that ruling, when deciding whether or not to send it to court, can only operate on the evidence in front of her.
Right, but she says, I said to her, is what he said to me threatening.
Sorry, hold on. She had in front of her. She had the police report. She had your testimony of what you think occurred.
There's no police report in front of her. All she had was I said, don't you have a police report? Meaning she'd go look it up. She'd go.
She clearly says that.
She says there is a police report.
No, she says you don't have a police. You ask, you don't have a police report there. She says I do.
Okay, she says, what you're trying to tell me to understand is that when I ask her, is what he said to me threatening, she says, I can't say. She's not allowed to go look that up in the criminal code book.
Hold on. No, she says, I can't answer. She's not supposed to answer that. It's not, the evidence is in front of her.
No, it's not evidence.
No, hold on. You claim you reported to police, but she didn't get that from the police.
No.
She makes it very clear.
She does not say she does not say it's not in the police report.
No, she says I have to deal with what I have in front of me. So she doesn't have that in front of her. She's not supposed to rule. She's not supposed to comment on something that she doesn't have in front of her. That would be irresponsible as a judge.
Oh God! You're telling me she can't go back on my word? Why am I testifying in that?
What do you mean?
I'm testifying to her. That's why she's recording the hearing.
Right. So now she's supposed to say, okay, she's supposed to take your word for it that that's what happened, without having testimony from the other person.
Well, she wants you to call up the other person.
So with that logic, you could have gone to her and said anything you wanted about what happened, and she's supposed to believe it.
Well, if she believes it. She believes it. If she doesn't, she can always say, I'll have to do some investigating, and then I'll check with the other person.
She can't rule on anything that's not in front of her, and simply you saying that is not enough for her to say, oh, well, that is a threat.
So how would you ever lay charges in front of a justice of the peace then?
That was supposed to be in the police report, but that wasn't in the police report. So
where does it say it's not in the police report?
She says it's not. She doesn't have that in front of her. She says, I can't say.
She doesn't say it's not in the police report.
Hold on, let me finish. She says, I can't say. I can't tell you that. I have to deal with what I have in front of me, and that's this.
Yeah, she can't tell me whether it's threatening or not.
No, she's not. She's not supposed to comment on something that she can't.
Where does it say she's not supposed to comment on something? Where does it say that?
Dealing with possibly laying charges against somebody, and
yes.
You're asking her to comment on whether or not something that she can't verify happened or didn't happen.
So how would you ever lay charges in front of a justice of the peace then? What is she taking my evidence for then?
Because she can't go. She says it even clear. She can't go any further than that. It's not her. Even though you wanted her to say something about whether it was threatening or not, she doesn't have to. She doesn't have that evidence in front of her. How is she supposed to rule on that?
What evidence doesn't she have in front of her?
There's nothing in the police report about that threat.
She didn't say that.
Yes, she does.
No, she doesn't. She does not say there's nothing in the police report that says that.
She does. She says.
No, she does not say that.
Listen to what I'm saying.
Ah, jeez.
I have to deal with what I have in front of me, and that's this. Just this, unfortunately, can't go any further. You reported it. She's asking you. You reported that threat?
Yes.
You say, yep. And she says, at that time? And you say, yep. So she didn't have it in the report because it wasn't in front of her. That's why she
did not say it's not in the report. She had no clue.
Why would she ask you if it's been reported?
Because she wants to know whether there's a police report, whether I brought one with me or not.
No, she has the police report in front of her.
No, I was there, guy. And she didn't have the police report.
So she's lying on
She doesn't say she has the police report. She says, yes, she can take it off the police report.
No, she does. Again, I'll say it one more time. You ask, you don't have a police report there? She says, I do. So is she lying when she says that?
Maybe she means she can get it off the police report. All she had in front of her was a tape recorder. I never gave her a file name or nothing. We'll get to the point.
So she's lying when she says that?
We'll get to the point where I asked her, is what he said threatening?
Yes. So no, hold on. Let's confirm this fact. She has a police report, unless you're saying.
I didn't see a police report in front of her. All she had was a paper cutter and a pad of paper.
So now you're basing that on what you saw in front of her.
Wow.
So let's clarify this again. When you say you don't have a police report there, and she says I do, is she or she not lying?
I don't know. She did not have a police report. She didn't take anything off of.
Based off, how do you know what the police report looks like? You're basing off what you saw on her desk. How is that evidence? Like, how are you supposed to? That means nothing. She's saying she has a police report.
Okay, so is what he said to me threatening or not?
Okay, so we confirm that. She has a police report.
Okay, she has a police report.
Okay, so she has details in there from the police that you...
You don't know what's in the police report. I don't know what's in the police report.
Exactly, but so you can't claim that there's no evidence that the police didn't investigate it, because for all we know, they could have, they couldn't have. But what we do know is that there was a police report.
Yes.
Now you go on to ask her about the threat.
Yes.
She doesn't say that that's not a threat.
She says, I can't say. Why can she not say?
Because would it not be irresponsible for her to say, yes, that is a threat, when she doesn't have evidence as to whether or not it is a threat, whether or not that threat was even made?
What do you mean she doesn't have evidence whether it's a threat or not? You look it up in the criminal code where it fits into the definition of threat.
The evidence of whether the threat was made is not in the criminal code. The criminal code defines criminal terms. She's saying she can't say whether or not that...
Guy, people testify. He said, she said cases all the time in court. All the time. She's not saying I don't believe you. She says I can't say. Well, why can't she say? Why doesn't she look it up in the criminal code?
That's even
so you're assuming I'm lying already. You're assuming that if I say to her he said these things, she has to automatically say I don't believe you.
No, she has to automatically look at the evidence in front of her.
Yes.
And she clearly says, I can't tell you that. I have to deal with what I have in front of me, and that's this.
What do you mean? Yes.
Have you reported it? She's asking you, did you report this threat? You say yes. So she doesn't even have that threat in the police report.
How do you know what's in the police report?
Because she's saying she doesn't have the threat in front of her, that the threat is not in what's in front of her.
Oh, you're crazy, man. You're making up stuff here. I'm laying evidence in front of her. That's what you do with the justice of the peace. You lay evidence in front of her. You lay your information out, and she decides...
Yes. And the only evidence of that threat is you simply saying... it.
Yeah, and she doesn't say I'm not credible.
That's not enough evidence for her to lay a criminal charge against somebody.
You think, what do you think they do in rape cases, when it's he said, she said?
But she's already concluded that even if that threat, let's assume that threat did happen, and let's say she said, yeah, that is threatening. What does that have to do with, now go back to the assault charge.
No, so what?
Clarified.
We're talking about why she's covering it up.
She's already clarified that you made the first initial contact and that you guys got into
Okay, go to section 34 of the criminal code. Go to the attachment. Go to Toronto Police attachment in that email.
I don't have it in front of me.
All right, well, go on the internet and look at section 34 of the criminal code.
Don't know if I can do that. Right, so do they believe on reasonable grounds that force is being used against them or another person, or that a threat of force is being made against them? That the act of... So what's your argument? I still don't see it.
I wasn't attacking him when he hit me. I was bent over, putting stuff in my gym bag.
No, but you've already acknowledged that you made the initial contact. So let's confirm this. So we've already confirmed that she had a police report, even though you initially said she didn't. Now let's confirm that who made the first physical contact. Because you even say yes, but it's pushing him.
When he hit me, was he being attacked?
Hold on. So you already pushed him. So you pushed him first, and then over the same issue in the same time frame, he hit you back.
No, you can't say the same time frame. The criminal code does not say time frame. It says that it has a reasonable belief that there's force going to be used on him.
No, hold on, I'll find it right now. The judge explains it. Yeah, she even says, but if it's an ongoing event.
Yeah, but the criminal code doesn't say if it's an ongoing event he can hit you back. It says he has to have a reasonable belief that force is going to be used against him.
Sir, you guys got into a fight.
I'm going by the criminal code here, right? I'm going by the criminal code.
Right, and so was the judge, and the judge determined that you two were in a fight.
You're crazy. And the criminal code says he has to have a reason. You can't just hit somebody because
you pushed him first.
And then we walked away from each other. Was he under threat?
According to the police report, according to what the judge had in front of her.
You don't know what's in the police report, so stop saying according to the police report.
Had in front of her, there is not enough evidence to say that it wasn't. There's not enough evidence to say that there was assault. According to what the judge had in front of her, it was a fight.
Yeah, but the criminal code says that...
No, it doesn't. No, because the judge interprets the criminal code and applies it to your case. The judge did that. The judge, based on what she had in front of her, determined that you pushed him first, which you don't even deny, and then by the time he reacted, it's still considered a fight. She considers it a fight, not an assault charge.
She can't. That's not a reasonable interpretation of the criminal code. The criminal code says he has to have a reasonable belief that force is being used against him. That's what the criminal code.
You initiated the first contact. What more reason would someone need?
He didn't hit me after. He hit me. We walked up to each other. He said, "Bob, take it easy." I walked away. I was putting stuff in my gym bag. He then walks over to me at least a couple of steps and hits me on top of the head. That's not defending yourself in a fight.
Your take on what happened.
Again, we're back to the he says, she says thing. Man, you are so screwing me around right now, man.
No, so the judge is just supposed to believe what you say and lay charges against somebody based on...
I didn't say that, so why are you putting words in my mouth?
So why do you find it surprising that the other person involved might have a somewhat different recollection of what happened?
We're not going on what might be here. We're going on facts. We're not going on might. We're going on facts.
Fact is what you think happened.
Yes.
Yes, but imagine if everyone who ever got accused of something or wanted to accuse someone of something simply said that this is what I think happened and it's fact.
But how do you know the justice of the peace can't launch an investigation?
They did. There was a police. How do you know the police didn't investigate?
I don't know whether they did or didn't.
So how do you know what was in the police report?
Well, you don't know what was in the police report either. But you're assuming there was stuff in there.
And now you want to lay, and then you wanted to lay charges against the judge.
A justice of the peace. And the police said I was right. The police said the justice of the peace is wrong, but it's no. They said the justice of the peace is right because it would be hard to prove the assault charge. They didn't say she was right because she interpreted.
Evidence, because the evidence isn't there.
My word is evidence. People testify in court all the time.
Not for assault, not for simple assault.
Where does it say this? Where does it say you can't testify? You can't take someone's word on an assault charge.
That's not enough for a judge to bring a court before a case.
Where does it say this? What do you mean? So there's a different standard for rape and there is for assault. Because I've never heard of a different standard in a court system.
So I honestly see nothing. I see nothing sketchy about what this judge did. This judge saw that you, based on what was in front of her, determined that you guys were in a fight, and therefore is not going to lay charges against somebody of assault when you assaulted the person first.
Yes, but when he assaulted me, he was not defending himself.
That's not how the judge saw it.
Because the judge is lying. That's why.
So what incentive would the judge have to lie about?
Because the courts are swamped, just like the police lie. It's the same reason.
Even though you acknowledge that you initiated first contact, that you hit the person first.
Yes, and then when he hit me, he wasn't being attacked. So charge me with assault and charge him with assault too.
You wanted the judge to charge you with assault as well.
Okay, if they go to him and he wants to file a charge of assault against me, he can go ahead and do that. So you're admitting he did assault me then?
No, you guys were in a fight.
You just said you want to be charged with assault too.
No, because you just said that. You just said charge him and yourself with an assault, with assault, and I'm questioning why you would suggest that.
Because your argument is that I hit him first. I just said to you.
Acknowledge that.
I just said to you he wasn't defending himself when he hit me, and you said, but they don't take your word on it in an assault charge. And I'm thinking they've never had. There's no difference if it's a rape case or not. If
the judge didn't see it the way you saw it, the judge ruled differently, said that you guys were in a fight because you hit the person
and
first,
she's lying.
The person responded.
The criminal code says it has to have a reasonable belief that force is being used against him.
Right, and according to from the judge's perspective, after reviewing the evidence that she had in front of her, which you don't even know what was in front of her.
You don't know either.
Right, but that's what I'm saying. I'm not the one making the charge that the judge is lying. You are. So where's your proof that the judge lied?
I can't investigate the judge. I want the police to.
What would the police investigate?
Whether there was a police report and what's in it or not.
But we know there was a police report. The judge acknowledges there was.
But you don't know what's in it, though.
Right, but imagine how are you supposed to investigate? Why would you investigate every single judge? Because the person.
Who said every single judge?
No, but imagine if every person who makes the case of assault did what you did and simply said, "Oh no, the judge is lying," and then all of a sudden.
Because on reasonable grounds, based on what the criminal code said, she is lying.
No, she's not lying. She interpreted what happened differently than what you believe it happened.
No, the criminal code says he has to have a reasonable belief.
And the judge believes he did.
Based on what?
Based on the fact that you hit the guy first.
Then we walked away from each other. The criminal code doesn't say you can hit somebody just because they hit you.
The judge doesn't believe that she doesn't believe that there was some sort of mass distance in between you guys and some huge time.
The criminal code doesn't say there has to be mass distance. The criminal code says that he has to have a reasonable belief that he is going to be assaulted. Force is going to be. So you're changing the criminal code around now.
According to what the judge had in front of her, by way of evidence, she disagrees with you.
And she's lying.
You can't. Okay, that's your opinion. That's what you think. You think the judge is lying. Now you want the police to investigate that based on what you think the judge was lying.
Well, look at what the criminal code says and what the evidence says.
And what? And based on what the criminal code said and what?
And what I said happened.
And what did she say that happened?
Well, why would she say what happened?
She said it's an ongoing event. She said that it was an ongoing event.
But the criminal code doesn't say it has to be an ongoing. If it's an ongoing event, you can hit somebody. It doesn't say that. It says you have to have a reasonable belief that your force is going to be used against you.
Right, and she believes that they did clearly.
But there's no evidence of that, though. Where's the evidence that I was about to hit him?
No, and there's no evidence of the counter story. And you're the one making the claim. You have to provide the evidence.
What do you mean, what counter story?
There's no evidence that there wasn't a threat, that he felt that there was an imminent threat.
I was there, guy. I was there. I know what happened.
So imagine if every case was just based on that, based on the testimony of one of the persons involved. Whether there was imagine if cases happened like that. That just because I believe this is what happened and I was there, so I say this, therefore anybody else who says anything else is lying.
No, I didn't say that. I didn't say he was lying.
Entire case on the fact that you think it happened this way, even though you were the one that hit him first.
That's got nothing to do with him assaulting me. I hit him.
That you hit him first.
Has nothing to do with it. The criminal code says that.
No, it doesn't. The criminal code clearly says that if the person, you're saying that he didn't have a reason to think that he was in danger.
A reasonable belief, yeah.
He could easily have thought he did. The judge easily.
But you don't know that, though.
But neither do you.
So the police need to investigate it then. Someone needs to explain to me.
No, the police didn't investigate it.
Not that, the justice of the peace. Police need to investigate the justice of the peace.
And how do you know the police didn't investigate the initial claim of assault?
I'm not talking about that. I'm talking about the justice of the peace.
The justice of the peace had a police report. How do you know what was in that police report?
I don't know. You don't know either.
But that's my point. I'm not the one making the claim that the judge lied.
I know I am. So the police need to investigate that then.
No. Why would the police just simply investigate it because you want them to?
So someone breaks into your house and you call the police. They don't have to come over. Just because you're saying someone broke into your house.
How is someone breaking into someone's house the same as you thinking that a judge lied about something?
No. You said your evidence is you just because of what you said happened, they're supposed to believe you. They're supposed to investigate it based on that. Well,
no, they have evidence. She has evidence in front of her.
You don't know what she's got in front of her.
And neither do you.
Yes. So I'm saying.
Though you're the one making the claim.
I'm saying what she did here doesn't make sense. So I would like a criminal investigation into it. with the police to investigate the justice of the peace.
How does it not make sense?
Because the criminal code says you have to have a reasonable belief.
The judge thinks that person did, seeing how you started the fight.
But the criminal code doesn't say that, though. It says you have to have a reasonable belief.
The judge believes that the person did have a reasonable belief.
She doesn't say that. She doesn't say that.
Well, no, but she's clearly.
But look at the evidence, though.
Code. No, because she's ruling based on the charge of assault. Judges then base their decision on the definition of assault. So she understands. I'm pretty sure she knows law fairly well. I'm pretty sure she understands legal definitions pretty well.
Yeah. So read the whole transcript, and it says we had a fight, and we walked away from each other. It says you made the first contact with him. I said yes, and Bob, take it easy. I backed off then, and then when he stood up again, we started arguing, and I said to him, "Are you threatening me?" He then said, "Bob, take it," and I said something like, "Take it easy," or something.
This is I'm not even sure what this is. Like
this is the transcript.
You're giving me.
I'm reading the transcript.
I'm looking at the transcript of what you said to the judge.
And then it says there's kids coming downstairs. So we walked away. He walked away from me, and then I was bent over putting stuff in my gym bag. The criminal code doesn't say you can hit somebody because they're bent over putting stuff in their gym bag.
That's not how the judge saw things. That's not what was, and you don't know. You have no idea what was in that police report.
Right. So the police need to investigate the justice of the peace then, and tell me what was in the police report.
Why would the police do that? How do you know what the police investigated?
No, I'm not talking about the assault charge. You're saying the justice of the peace is not lying.
The other guy. How do you know the police didn't talk to the other guy?
I don't know that. The police can tell me that.
So how are you accusing the judge of lying when you don't even know what the judge looked at?
Because I'm using common sense. And if you read the whole entire complaint,
you're using common sense.
You read the whole entire complaint. The police don't say the justice of the peace made her decision based on the police report. The cop at the front desk said the justice of the peace is right because the assault charge would be hard to prove.
It doesn't matter what the police said. It matters what the judge says in her ruling. Why is that funny? You're saying that the judge...
I'm saying I want the police to investigate them. You're saying, so the police got to investigate just because you say it. Well, the police didn't say this. The justice of the peace had more evidence in front of her.
No, the judge made her ruling based off of what she had in front of her.
Yeah.
You have no idea what she had in front of her. You didn't even claim that. You initially claimed she didn't even have a police report. She does.
Okay, so the police need to investigate the justice of the peace then to see what was in the police report.
The police have to investigate the justice of the peace.
For obstruction of justice. Because there's reasonable belief there that she obstructed justice.
There's no evidence at all that she obstructed evidence. There's not.
How do you know that? If you don't know what's in the police report, how do you know that?
Even just based off the transcript, there's no evidence of that.
But the criminal code doesn't say you can hit somebody because they're bent over putting stuff in the gym bag.
That's not what the judge believes happened.
The judge didn't say something else happened.
You can't just get police to investigate judges because you don't agree with their ruling.
Sure you can. Sure you can. If the ruling doesn't make sense.
Yes, you can ask them to investigate it, but there's absolutely no way do they have to investigate.
Yes, they have to investigate it. The Supreme Court says that.
They do not have to just. If you don't have evidence to support an investigation, they're not just going to investigate judges.
You didn't say I didn't have enough evidence. You said they don't have to investigate. You said if it's not reasonable, the judge's decision, they can investigate the judge. And what that justice of the peace said is not reasonable.
How is what that justice said not reasonable?
Because look at what I said. The criminal code doesn't say you can hit somebody because they're bent over putting stuff in their gym bag.
You can't keep saying, the criminal code says this. The judge doesn't interpret what you happened to be the way that you claim it as. The judge thinks it happened. The judge determined it to have happened another way. The judge is well within her.
But the criminal code doesn't say it can happen another way. The criminal code
has nothing to do about what happened to you.
The criminal code has everything to do with it.
No, the criminal code states with the definition of a crime. It doesn't talk about what happened in your specific case.
Yes. So what was his evidence that I was about to attack him?
What do you mean? He could have easily said he hit me, so I hit him back. Done.
Yeah, but that's not what I said, though. But you don't know what he said, though.
Yeah, so there's two conflicting stories.
You don't know what he said.
You guys are in a fight. It's completely reasonable for the judge to then say, you guys are in a fight.
Well, it's not completely reasonable, because the fight ended and we walked away from each other.
It's entirely reasonable for a judge to see that somebody hit somebody, that person hits that person back.
No. Look at the transcripts. It says I backed off then, and then he stood up and he started arguing, and I said to him, "Are you threatening me?" And then he said, "Bob, take it easy." She said, "No, that's not what's in the transcript of the judge." She didn't say that. She doesn't say that. She doesn't talk about the transcripts at all.
No, I'm looking at the transcript of the judge.
That's what I'm reading in the transcripts.
Yes, and you after looking at after hearing what you said and having what she has in front of her, which includes a police report,
which you don't know what's in it.
Doesn't matter. She has a police report.
Yes.
None of us know what's in it.
Yes.
But you're the one making the claim, not me.
Based on what I know, yes, she's covering this up.
No, she's covering it up. So
because it's not reasonable what she said.
Everyone who got convicted with a crime, who even accused someone of a crime, and the judge says, no, that doesn't happen. Imagine if everyone just simply said, no, well, that's not what I think happened. I want people to investigate it.
Right, they would investigate it and see if there's any other evidence. They would ask him, do you have any other evidence? Is there a police report? What's in the police report? Sure, if the guy says, oh, that's not what happened, but there were 7 witnesses at the trial that said it did happen, they're going to say, well, look, there were 7 witnesses that said it did happen, so we're not going to believe you. So not just because everybody says that's not what happened, do they have to investigate? No.
I honestly don't. I can't believe how straightforward and clear this case. This specific one seems to me. This one seems to be more irrational for you to pursue than the other one. This is a case of you hitting somebody, and then that person hits you back.
Later, yes, after we walk away from each other.
According to you.
According to the transcripts. Well,
no,
so you keep saying according to you, but you don't know what's in the police report.
Saying it doesn't make it evidence.
Sure it does. People testify in trials all the time, and that's evidence.
That's just your account of what happened.
Yes, and people testify into their account of what happened in trials all the time.
So the judge then has to take into account what you're saying.
Yes.
Has to take into account the police report.
Which you don't know what says.
Whatever other evidence that judge has, and then has to make a ruling.
Yes.
Now you don't know what other evidence that person had.
Yes,
but
that's right.
Said she had a police report in front of her, and she has your testimony, and she also has the testimony of you saying that you started the fight by hitting the person first.
No, so you keep going back to that when the criminal code doesn't say you can hit somebody.
No, but that's still evidence that you hit that person first.
Yes.
So now she has to, in her head, determine what's more likely. That person then took a break and then decided to hit you, or did that person then retaliate?
What's her evidence of that?
No, but that's what the...
But she has no evidence that contradicts me, though.
How do you know that?
How do you know she does?
I'm not the one making the claim.
But you're saying she based it on that.
No, I'm saying...
You just said she based it on the police report.
That person has in front of her.
Yes, you're saying she based it on the police report, which you don't know what was in it.
Right, and neither of us do, but you're the one...
So why are you saying that I'm wrong, then? That the justice of the peace needs to be...
You don't have a case.
Against the justice of the peace.
No, yes, because you're the one saying she's lying, so you're the one who has to provide evidence of that she lied.
There's evidence right there. We walked away from each other, and then he hit me.
So according to your account, you think she's lying because she's not agreeing with you.
She's not agreeing with what the criminal code says.
No,
she's not using that interpretation.
She's not agreeing with you.
No, she didn't say she didn't agree with me. She said
agreeing with what? No, she's not agreeing with your account of what happened.
She didn't say I don't agree with you. She just says...
She says it explicitly. I'll read it to you right now. Hold on. But if it's disputed, I'm going to comment. No. Okay, so she says, fortunately, Mr. Burgess... Okay. Unfortunately, Mr. Burgess, that is the dilemma. You made the first physical contact, and so technically you commit the first assault.
Yes,
so right there she's saying hold on. So right
you said she disagreed with me.
No,
that's what you just said. You just said she disagreed with me.
I'm not finished yet. she's saying you made the first assault. So right there, just to begin with, she's already saying that you committed the first assault. So automatically she's not agreeing with your opinion that there was a break in between. She's automatically already saying
come on.
the first assault.
She doesn't say that.
She says it right there, that you made the
She
first
doesn't say. She doesn't say that there was no break.
She says that, so technically you commit the first assault.
Yeah, she doesn't say there's no break between us.
But if she's saying you committed assault, the first assault.
Or maybe she's lying.
Oh, so now she's lying.
Well, the cops do it. It's been going on for 20 years.
Okay, and then she continues. She says, you say yes, but it's...
Hello?